Yes, I salute you all. Thanks for listening and thanks for watching. So basically today we are under the sale of goods and the topic of emphasis that we are going to look at, we are going to look at the passing of property between the seller and the buyer. Basically that is the topic. But the major rule that you have to know, however much you shall go to know the rules, but the principle what you have to know that risk passes with property. Or property passes with risk. You get where there is passing of property, risk has followed the property. So basically, note that in mind. And if you read the case of the book of Atiya, sale of goods, it implies that the loss of goods may depend on who has the property, which means the risk passes prima facie when property passes. And basically here, the seller can only sue for the price of the property that has what? That has passed. So basically note that in what? In mind, that risk passes with property. You get? Basically what you have to know, and also the risk also, or the property to pass depends whether the goods are specific or unascertained. Here, the key element, or what you have to know is that, we have like two types of goods. We have ascertained goods and future goods. Future goods, we can categorize them as unascertained. Ascertained, those are specific goods whereby you have identified the quantity, the quality, the number. Those are specific goods. They are the goods that are ascertained, the quantity and everything. That if I'm buying Porsche, I know the bags of Porsche I'm taking. Those are ascertained goods which are specific. But future goods, those are goods that are even not, they are not manufactured. You haven't seen them. Basically, they are unascertained. So basically, note that in what? In mind. Risk passes the property and risk passes in ascertained goods. However much you shall see the rules, basically, as we are moving further. So basically, what you have to bear in mind under here, when you read the section 25 subsection 2 of the sale of goods and services, provides that where there is a contract of sale of specific or ascertained goods, the property in the goods passes to the buyer at such a time the parties to the contract intend to pass. That is where there is section 25 subsection 2. But when you read section 22 of the sale of goods and supply of services, it provides that regarding to unascertained goods, the act provides that where there is a contract of sale of uncertain goods, property in the goods shall pass to the buyer until goods are ascertained. So note that in mind, or bear that in what? In mind. And another thing, what you have to bear in mind, there is a case of Jane Bwinza. Jane Bwinza versus John Nathan Osapil. Under this case, the court held that the fact that the buyer allowed the respondent to retain critical documents of title, such as the logbook, shows that the intention of the parties was the property in the vehicle would not pass at the time of selling of the sale agreement. So if I retain the logbook, shows that the intention of the title was not, property was not to pass at the time of signing the sales agreement. So basically note that in mind. And they went further and said that where a contract contains an express provision regarding when the property is to pass, there is no controversy. However, in the majority cases, the contract is silent on the matter, in whereby the rules are laid down in section 26 of the sale of goods and supply of services act, section 26. This is where we are going to see the rules as to passing of property and risk between the buyer and the seller. But just no property passes with what? Yeah, property passes with the risk passes with property. So under the rules that are provided under section 26 of the sale of goods and supply of services, we are going to analyze each subsection or each paragraph in section 26 to ensure that the rule and ascertain that rule. You get. First of all, under section 26A, it provides for the first rule that as to the passing of property, where there is unconditional contract for the sale of specific goods in a deliverable state, the property in the goods passes to the buyer when the contract is made, and it is immaterial whether the time of payment of delivery or both are postponed. So basically note that in mind. And in this essence, it says that where there is an unconditional contract for the sale of specific goods in a deliverable state, the property in the goods passes to the buyer when the contract is made, and it is immaterial to the time when it will be delivered. You get, or when payment is made. So basically note that in what? In mind. The case of Osapil versus Kadu. The case of Osapil court held that a registration card or a logbook was prima facie evidence of title of a motor vehicle, and the person in whose name the vehicle was registered was presumed to be the owner unless proved what? Otherwise. You get. Basically, that is specific and indirect. Actually, now there is what amounts for something to be in a deliverable state. Here, what you have to bear in mind is that saying that goods must be in a deliverable state, it implies that if at all you are sending me goods, they must not be in a bad condition. They must be in a state that is deliverable. Take for instance, let me give an example, is that you are selling to me maybe bags of rice, but as you are loading them, they get some damages. So those goods lose the meaning of the deliverable state. A deliverable state is something that is in a good what? Condition, basically. And when you read the case of Underwood Limited versus Bang Castle Brick and Cement Syndicate. You get, Bang is B-U-R-G-Y. Bang Castle Brick and Cement Syndicate. Basically here the seller sold a 30-ton condensing machine free on rail, London. At the time of sale, it was embedded on the floor of the factory. And in this essence, the seller dismantled it and proceeded to load it on the truck. And so doing, the machine accidentally broke. So court rejected, and it said that the engine was not in a deliverable state. So that is the element that I was trying to portray, basically. That is one of the first rules. There must be unconditional contract for specific they must be in a deliverable state when passing of property. Secondly, second rule is under section 26B. Under section 26B provides for the second rule. And this second rule, it is that as to matters of passing of property, it provides that where there is a contract of sale of specific goods, we know what is a contract of sale of goods provided under section 2, subsection 1 of the Sale of Goods and Supply of Services Act. And even the interpretation section gives the same. So it provides that where there is a sale of specific goods and the seller is bound to do something to the goods, for purposes of putting them in a deliverable state, the property shall not pass until that thing is done and the buyer is noticed. Here, what do I mean by that? And the buyer must do something to the goods for purpose putting them in a deliverable state. Let me give an example. Realize that we may go to buy goods. Let me give an example. We may go to a factory to buy like 100 kilos of maize flour. But however, I just want 100 kilos of maize flour. So the seller must do something, which is packaging them maybe in a sack of 100 kilos, or 10 kilos. But the thing is they are packaging so that they be in a deliverable state. Basically here they are trying to imply property shall not pass until that thing is done. That's the essence that I'm trying to bring in mind. And that is rule 2. Then there's rule 3, it is provided under section 26C. Section 26C provides that where there is a contract of sale of specific goods, where the contract of sale of specific goods in a deliverable state, but the seller is bound to weigh, to measure, test, or do something in reference to the goods for purpose of ascertaining the price. The property does not pass until that act or the thing is done and the buyer has notice of it. You get? So basically, rule 2 and 3, it provides that the seller is bound to do something in reference to the goods. That's rule 2 and 3. The buyers must do something in that regard. So in this essence, all what you have to bear in mind here is that rule 3, you have seen to weigh, measure. You have seen you go to the shop to buy 1 kilo of sugar, but the seller must first weigh that 1 kilo so that he puts those goods in a what? In a deliverable state. You get? So basically, note that in mind. And under rule 3, we have a case of tally versus bats. Tally is TURLEY versus bats is BATES, whereby here a party sold to another party a heap of clay at a certain price, and it was agreed that the buyer would load the clay and weigh it to certain the price. So the property passed to the buyer when the goods were ascertained. You get? So basically, note that in mind. And when you go to rule 4, which is rule 4 under the rules of passing of property, we go to section 26D. It provides that where goods are in the delivered to the buyer on approval or on sale or retain or other similar terms, the property and goods shall pass to the buyer under the following. There are 2 conditions, under 2 conditions. You get? And one of the conditions that we shall see, when he or she signifies his approval or her acceptance to the seller and does not do any act or does any act that adopts the transaction. That is 1. 2, when he or she does not signify his or approval or acceptance of the good but retains the goods without giving notice of rejection, then the time has been fixed and until the expiration of the what? Of reasonable time. Those 2 conditions make the property to pass. You get? Where the goods are delivered to the buyer on approval. The buyer has to approve or to retain whatever. You get? First of all, the condition when the buyer approves, when the buyer does not have signified approval but retains the goods. You get? Then property passes. We have the case of Kingham versus Attenborough. Kingham, Kirk, Ham, HAM versus Atten, ATTEN, Bori, BOROUGH, Attenborough, where court held that the position of a person who has received goods on sale or return is that he has option of becoming the purchaser of them, and they become so in 3 different ways. First of all, he may pay the price, he may retain the goods beyond reasonable time from their return, and he may do an act inconsistent of his being and other than a purchaser. You get? So basically, that is rule number 4. And rule number 5 is provided under section 26E. Section 26E provides where a contract of sale is of unascertained goods or future goods by description, and that of the description in a derivative set and the condition, and there is basically the goods are in a deliverable state but they are uncertain of future goods, and in a deliverable state are unconditionally appropriated to the contract, either by the seller with the assent to the buyer or by the buyer with the assent of the what? Of the seller. You get? The property in the goods passes to the buyer, and such assent may be implied or express. You get? That is section 26E. Then when you go to another rule, which is provided under section 26F. It provides that where the contract or where the seller delivers the goods to the buyer or a carrier or a bailee, whether named by the buyer or not, for purposes of transmission to the buyer, and does not reserve the right to disposal, he or she is taken to have unconditionally appropriated the goods to the contract. Basically, there the property has passed. And a good case, we have the case of Pignatoro versus Gilroy. Pignatoro versus Gilroy. Gilroy is Gilroy. Gilroy. Pignatoro. So basically, under this case, a sale of bags was delivered to the seller's place of business, informed the buyer that bags were ready. On receipt, the buyer did not do anything for more than 3 weeks, but he notified the buyer that your goods are ready. But the buyer did nothing for 3 weeks, and during the time the bags were stolen. So court held that the buyer had, by his conduct, assented to the seller's appropriation, and according the property and the risk had passed to the buyer. You get? Read that section 26, clause F, whereby if the seller delivers goods to the buyer or a carrier or bailee, whether named or not, you get, for purpose of transmission, and does not reserve the right of disposal. Reserving the right of disposal is that he has left, he cannot dispose them again. Now the onus is the buyer. You get? So basically, note that in what? In mind. Then we have section 26, another rule under section 26G. 26G of the sale of goods and supply of services. Actually, this section or this paragraph provided the doctrine of ascertainment, or the doctrine of ascertainment by exhaustion, to exhaustion. It provides that where there is a contract for sale of a specified quantity of unascertained goods in a deliverable state forming part of the bulk which is identified in the contract or by subsequent agreement between the two parties, and the bulk is reduced to less than that quality, if the buyer under the contract is only a buyer whom the goods are due of the bulk, the remaining goods shall be taken as appropriated to the contract. Basically, note that in what? In mind. And in this essence, what you have to put in mind, or what you have to bear in mind here, the property passes shall pass. You get? And the doctrine of ascertainment or by exhaustion refers to a situation where the stock from which the goods are drawn is duplicated successfully by withdrawals until all is left. You get? So basically, that is under section 26G. You get? Here it introduces that ascertainment of goods by exhaustion. Here the goods are in the deliverable state, but they are uncertain and they are in the bulk. But however, the bulk is identified to the buyer, and the buyer has assented on it. You get? And the buyer has agreed that the buyer and the contract due to the bulk remaining and the goods are separated. You get? So basically, note that in mind under section. We have the case of Waite versus James. Waite and James versus Midland Bank. Under this case, the court observed that ascertainment can be achieved by method other than that in what? In section 26E, as you have seen the rule there. You get? So basically, other than that, that is the rules of passing of property. But property passes with what? With risks. But other than that, thank you for listening, and thank you for being on. Wish you the best.